tonight, it occurred to me that there are cases, I think there's a line of cases about the circumstances in which a broker can get damages as a result of the failure of one of the parties to perform the main contract. I'm pretty sure there are such cases in the shipping context and maybe in other contexts as well. That sounds potentially relevant to the claim that you're making, but I don't think those cases are cited in either party's skeleton. Maybe because you've looked at them and they don't help, or maybe for some other reason. But I just put that out there.
We're looking into how we can assist in our note tomorrow morning. My Lord, back to the Commission contract. We were looking at clause 3.1 on page 433. And I want to just go back to the calculation. So it finds the Commission payable. The obligation was absolute. Shall pay on for each shipment. It's not purporting to say for a shipment, so long as something else happens. It's for each shipment under the contract. And it's calculated A less than B, where A is equal to a total of 0.50p multiplied by the number of goods, minus B is equal to the sterling equivalent of the total amount paid by Uniserve to the supplier for that shipment. So we say that is essentially an end to the matter. They have to pay.
Paid or payable?
Well, that is the only other question that rises. But I think when we look at clause 5.3, well,
at the end of the matter.
I was just going to. It doesn't read well, but I think it would be better construed as payable. But even if it is paid, then if it is to be construed as paid, then we are to be paid when it is paid. But it seems to be, particularly when you take it with clause 4, which assumes that things are going to be paid when payable.
Well, the price has not been paid and is never going to be. What,
we'll come to that in 5.3.
What, if anything, is going to be paid is damages for non-acceptance.
And we come to that in 5.3. But I'm going to do 4 first. Clause 4, invoices and payment. So it is not, doesn't refer in the heading at least to the accrual of the debt. It's just a matter of payment.
And sorry, just going back to 3.1. When it says the sterling equivalent, I'm just trying to unpack how you read this. You say B is equal to the sterling equivalent of the total amount paid for that shipment. Now, you said, well, actually it means payable. So the commission is paid irrespective of whether Uniserve pay. And the sterling equivalent, the date would be which date?
The date that it is either payable or paid, depending on how you construe it.
So it would be under the contract, I think you say, when the goods are available for collection?
Well, the contract has its own provisions for payment.
No, sorry, when does the obligation, as I understand it, your submission is clause 3 creates a freestanding right to commission, and the rest is mechanics. So when does the right arise? Is it when the supply contract requires the goods to be available for collection, because that's delivery or collection at least? It's at that stage,
I think
not any later stage.
We go further, that it is the date on which the supply is supposed to be made. The shipment is supposed to happen. Because there's this saving, because of the effect of it being by reference to the total amount paid, that takes account of any difficulties between Hightex and Uniserve. So it can just be read in accordance with 1.2 that they are shipments to be made under the contract, and essentially will be the date of that shipment. Now, Clause 4 is, we say, makes it clearest that there is a mutual assumption of common intention that all the shipments will be delivered to the UK on the date that each shipment arrives in the United Kingdom. What it doesn't say is on the date each shipment that arrives in the United Kingdom. It also doesn't expressly purport to have any precondition. It doesn't purport to override Clause 3. It really is setting out the mechanics and the information that is necessary. But I'll develop that in due course.
It was the question Lord Justice Phillips raised this morning, which I sort of had a tilt at a few moments ago. Clause 4.1a appears, at least on one reading, to suggest that the date for the selection of the exchange rate for the purposes of 3.1b is the date on which the shipment arrives in the UK.
My Lord, yes.
But if that's right, then
But
how does...
Well, it doesn't. Actually, it doesn't. It doesn't necessarily mean that. It just says the exchange rate applicable. So it's got to work out what the applicable exchange rate is.
Right, so that's...
Sorry, it's the other way. It's the other way around.
So you said that's the date on which you have to state but not the date. It's not the date by reference to which you state the exchange rate, but it is the date on which you have to work out what it was.
Yes, it's just setting it out. It's not making any provision that it is there. Of course, all this is happening without Caramel knowing what's been going on. So it's these, we say, essentially provisions to tell them what has happened so that they can raise their invoice. And an invoice, as we'll say, has no magic in it. It's just a demand for payment of an existing debt. It doesn't create the debt. It's just a demand for payment. And then we have some banking details and provision for payment of 2 days after. But I'll come back to that in due course. Clause 5, we have what is headed the refund provisions. And we rely principally on 5.3. In the event that the supplier, Hightex, disputes that, and then to avoid confusing ourselves too much, we move to the or. So in the event that the supplier disputes that Uniserve has the right to set off or is otherwise not obliged to pay any amount to the supplier pursuant to...
Isn't it in the event that ... Uniserve has the right to set off or is otherwise not obliged to pay?
Well, there are two that it disputes, and then you can take whichever that you like and leave out the other. So it disputes that Uniserve has the right of set off, or is otherwise not obliged to pay.
You've got to read this by reference. You've got to start with clause 5.1 to make sense of 5.3. I think diving into 5.3, I think you've got to go on this. You've got to start with 5.1, haven't you?
Well, in my submission, no, because it is first making provision for the refund amounts, but then it's also referring to or that Uniserve has the right to set off, or is otherwise not obliged to pay any amounts to the supplier pursuant to the supply agreement.
Okay. 5.3 starts, in the event the supplier disputes that it's under an
Yes.
obligation to refund amounts paid under the supply agreement to Uniserve.
Or,
Well, hang on.
sorry,
Just roll with me for the first bit.
yeah,
All right. That suggests that somebody has said something to the supplier that the supplier disputes. Don't you get that? Don't you get that from 5.1? Because in the event that Uniserve notifies the introducer that Uniserve considers the supplier is under an obligation to refund amounts paid under the supply agreement, and then doesn't 5.3 deal with in the event the supplier disputes that? Isn't that at least one of the options there? Just before we get into the really get deep.
well, it certainly includes that.
Okay, well,
But
just starting with that bit then, before we get into the real minutiae, they are linked, aren't they? I mean, 5.1 is linked to 5.3 is what I'm trying to put.
it is also linked. But clause 5.3 goes further than the mere link.
It may well be, but you just asked us to dive straight into.
Oh no, sorry, it was because once you've got past the obligation to refund, we say there are separate instances here.
Okay.
In fact, my lord, I think paragraph 5.1 makes the same point. It's also in the alternative.
So, if there's a dispute between Uniserve and the supplier about defective goods, say, Uniserve says, well, we're entitled to a refund.
Yes.
Then,
But it's
if it's accepted, if it's accepted that they're entitled to a refund, you get no commission. If you've already received the commission, you've got to refund it.
but it goes further.
And then if there's a dispute between them, you've got to wait. You've got to wait, is this right, until resolution.
Until resolution, and then you get paid on the damages, essentially. You get paid on amounts payable, adjudged to be payable. But 5.1's in similar alternative terms. It starts with notifies the introducer that Uniserve considers that the supplier is under an obligation to refund amounts paid, or Uniserve has the right to set off, or is otherwise not obliged to pay any amounts to the supplier under the supply agreement. It's not simply dealing with refunds. So where there's a dispute, the liability is postponed to the amount adjudged, so it's not actually when paid, it becomes payable at that date. One can refer that back to what is meant. And that effectively self-polices the entire mechanism. Because Caramel is owed a proportion of what is paid to Hightex, payable to Hightex. And Uniserve has its complete protection in those two clauses. And that applies even if Hightex has not complied with its obligations, because Uniserve won't have to pay. So clause 3 can apply, but of course the monies aren't payable. It only arises if the monies are in fact payable.
I mean, standing back, your case, as I understand it, is really as simple as this, that if Hightex is entitled to damages from Uniserve because it delivered goods under the contract which Uniserve wrongly failed to pay for, and collect, whoever it is, Caramel ought to get its commission. But on the other hand, if Uniserve was entitled to terminate the contract, then it doesn't have to pay a commission.
My Lord, perhaps I should have
on the
moved
goods not delivered. I mean, that is that.
I might have moved my final paragraph to be my first paragraph instead. Yes, that's precisely what he was saying. If anyone had looked at this contract and thought, if high-techs are getting paid, Caramel get paid.
And all the rest, payment and invoices and exchange rate dates, is just machinery.
Yes.
I mean, I'm not saying that's right, but that's your case.
That is entirely what we say. The rest is just mechanics, arithmetic and mechanics.
Right.
Passing of information.
Okay. Is there anything further then?
As to the terms, there's the acknowledgement at 6.1 that the agreement doesn't represent a commitment to Uniserve to purchase any goods from the supplier. We say that doesn't. It looks like an import from an ordinary agency contract, because here the commitment is passed. We don't rely on the commission contract for giving rise to that obligation. The supply contract gave rise to it, and we're being paid by reference to the supply contract. Paragraph clause 10 on 436. There's a no oral variation clause. It wasn't relied on below, but it's relied on now. And I'll come on to that in due course. Very shortly. Clause 10.5 is an entire agreement clause that the parties didn't rely on, but the judge did. But we say it's not relevant and it's not relied on now. And 10.6 is an important clause. The judge relied on the first part of it about reliance on representations, warranties, or other undertaking or understanding. We say he was wrong on that, but the second part, the important part, that is relied on against us today, is that all conditions, warranties, or other terms implied by statute or common law are hereby excluded to the fullest extent permissible by law. It wasn't a point taken against us. Oh, sorry, it was referred to but not expanded on below. It's not used as a reason to uphold the judge's judgment. He didn't refer to that second part. But in any event, there are two sorts of implied terms, as Lord Neuberger makes clear in the Marks and Spencer case. There are those that are implied from the surrounding facts and the express words. I'll go to it now. And then secondly, there are those implied by the law, by either statute or common law. And they're two distinct classes. Yes, the authorities bundle. Tab 25.
I think we know if it's simply to show that there are terms implied by law and terms implied in fact, I think we're probably quite familiar with that.
All it is to say that they're two distinct categories.
Okay.
And we say this clause is clearly only referring to those implied by law and not those implied by the facts.
Liverpool City Council and Owen type clauses. Liverpool City Council and Owen type clauses.
Yes. Ones that are public policy owing to the relationship between the parties. Those sort. Yeah. It's at paragraph 15 of Lord Neuberger's. So page 649. The authorities bundle. paragraph 15 at the bottom of the page. We simply say there are two distinct categories. I think Chitty denotes them as implications of fact and implications of law. But we say that that clause doesn't exclude them, and it would need very clear terms to do so when, if a term is to be applied, it's thought to be necessary for business efficacy of the contract. My lord, that's the terms itself. I've been through the factual matrix. And we've looked at clause 3. But there is the no oral variation. It wasn't taken below, but it's now essentially said that if shipments were not made in accordance with the schedule that appears in clause 2, then we cannot recover. Sorry, in clause 1.2. Because shipments only refers to these precise shipments being made. And are fortiori with the revised schedule that we would not be entitled to payments under this contract. Now we say that is obviously unfair. Caramel wouldn't even know whether it had happened. It's entirely in the power of High-Techs and Uniserve to vary their contracts. It may be that they simply, out of expediency, bring a shipment forward. Could it possibly be right that by an informal agreement or a formal agreement that a shipment is made in advance of the time and it now no longer qualifies for commission? What we say is 1.2 is really just referring to shipments made under the contract, in respect of which payments are going to be made by Uniserve to High-Techs. And it is not to be taken when it describes or repeats the contents of the supply contract, the original supply contract, unvaried, that those are set in stone for the purpose of the commission.
What if the supply agreement had been varied to increase the quantity, to say 100 million?
We say that it would have applied and the commission would have been paid.
Because that was fair?
Because it was made under the supply agreement which we had introduced. Now, alternatively, it does say total units scheduled, 80 million. But again, it's only really referring to a schedule.
What if they changed the price?
Again, because the way this works is for us to be paid with reference to the price.
What happens if the...
And we'd be paid less the other way.
Along similar lines, maybe this has been just asked, but what happens if according to the supply contract, High-Techs is entitled to supply less than 80 million because of the construction of the supply agreement, which I think, as I understood it, may end up with High-Techs saying that they wouldn't need to supply 80 million. They may end up supplying less than 80 million because they would be entitled to claim damages for some of those instalments. How does it work?
We say that those payments, should we obtain a judgment, keep our judgment, then we're entitled to be paid in relation to what is a judge payable to us under that contract, under that judgment.
Well, yeah.
So it's in reference to shipments that are made within the supply contract.
Yeah. As I understand the argument that we had the last couple of days, high-tech say if Uniserve don't turn up and collect,
Yes.
that's something which they can then treat as entitling them to sell that consignment.
Yes.
Using the word consignment
Yes.
usually.
We say that.
And claim damages. So they would, on that hypothesis, not be actually, quote, shipping anything. They'd just be claiming damages.
No, but what we say is that would still have been a shipment
Right.
due under the supply agreement. A shipment falling within the supply agreement.
And that's
And the
why-
money paid for that would be money payable under the supply agreement.
well, payable in other words.
Paid up.
'Cause your commission would be calculated on the price that would have been payable, not by reference to the damages claim.
Except that it's in proportion to paragraph 5.3. It's only paid to the extent that amounts are agreed or adjudged to be paid.
Yes, but, sorry, maybe I'm being dense or not explaining myself, both of which are possible. This is a situation where Uniserve doesn't comply with the contract according to High-Tech's. Uniserve doesn't come and collect. High-Tech says, okay, you didn't come and collect. We're now entitled to sell that proportion, that number of masks,
Yes.
which you were obliged to come and collect and didn't. We've sold them, and we're going to claim damages against you, Uniserve, for breach of contract. The damages that Uniserve would pay are not the contract price, as I understand it, but they'd be paying the loss of profit that High-Techs would suffer in relation to that consignment. Okay?
Yes.
Good so far. How do you factor that into the calculation of the commission under 3.1? Is it that it all turns on the word paid in 3.1b? Because if you can't say it's paid by Uniserve, because Uniserve is only paying damages equivalent to the loss of profit, you have to go back and say it's payable under the contract, the contract price. You want the commission on the contract price, I think.
Yes.
It's not. Sorry, I'm trying to over labouring a point.
No, I think that is correct. We won't pay of the contract by reference to the contract price.
And I'm not sure at the moment what 5.5 has to do with that that situation at all, because 5 is dealing with, I think, where Uniserve is saying some of the goods are defective or otherwise we want a refund, or there's some dispute, but it's not where Uniserve has failed to comply with the contract, is it?
Well, it's what I mean. 5.1 and 5.3 are in similar terms, largely, in what they apply to. And as I said, in the event that the supplier disputes,
Yeah, but it's all to do with refunds and stuff. This is.
but it isn't. But it's not all to do with 5.1. The introducer that, in the event that Uniserve notifies the introducer that Uniserve considers that the supplier is under obligation to refund amounts paid, or Uniserve has a right of set-off, or is otherwise not obliged to pay. It starts with refunds, but that's just the first of many alternatives of Uniserve saying I'm not paying, or want a refund. Only the first or is referring to refunds. The rest is referring to any other sort of dispute. Cash prices 1 or 2, and then otherwise disputes.
All right. And so the last, then to pick up that point, I understand the point you say, if there's a dispute, Uniserve says we're not obliged to pay, then there's a resolution of that dispute,
Yes.
and then it says the commission shall only be payable to the introducer once the dispute has been resolved, and to the extent that amounts are agreed or adjudged to be payable by Uniserve to the supplier. Well, it would be damages for loss of profit. So does that mean you only get your commission on the loss of profit, or do you get your commission on the sale price?
The express words of 5.3 I think in adjudged to be payable, it must refer to the damages.
So then you'd get, and what's the commercial rationale for that? So Uniserve breaches the contract, has to pay not the actual contract price, but loss of profits suffered by Hightex. And you're
we
entitled
will
to commission only on the loss of profits
Yes,
payable by Uniserve.
unfortunately. Unless it is possible to say that it's to the extent that amounts are agreed or adjudged, and one reads into that some pro rata adjustment.
That gets you into the difficulty, which my lord has pointed out, that it doesn't really work in accordance with clause 3 to calculate commission on damages, which might suggest that clause 5 is talking about payment of the price, and that a claim for damages based on failure to perform the main contract is governed outside this contract, subject to the entire agreement clause, by the kind of cases that I referred to at the beginning of the afternoon. Although I don't quite know what they say, but I do know,
I'm afraid
I do know there are such cases.
We say that clause 3 sets out what we're entitled to be paid, but there is a limit imposed by clause 5.3.
Because, right, I mean, if Uniserve, I mean, I'm not saying this is the facts, but I'm looking at this as contracting parties at the date in which the contract is entered into, and you've got this officious bystander tapping you irritatingly on the shoulder, saying, what do you mean? Let's assume Uniserve just decide that actually their interests are better served in not paying for these masks from Hightex, because actually they can get masks more economically or otherwise to fulfill an opportunity they've seen from somewhere else, and they just calculate that it's in their interest to just breach the contract with Hightex, just not pick up and not pay. And so they just don't pick up and don't pay. Hightex sues them for loss of profit,
Yes.
which I think is what Hightex's claim amounts to.
Yes.
Because it's done by reference to section 50 and whatever. So Uniserve only end up, through its own wrongdoing, paying a lower sum than the contract price, but just loss of profit. your commission that you're accepting is only payable by Uniserve on the loss of profit, damages, and not on the contract price. So Uniserve would be permitted in those circumstances by its own breach of contract of the supply agreement to reduce the amount of commission payable to you. Because I think the cases my lord is thinking about probably very much get into that territory. And certainly I can think of one or two that do. Couldn't tell you what the names of them are, but I've seen them. Where, you know, the general proposition is you shouldn't, in essence, be able to rely upon your own wrongdoing to deprive a commission agent of their commission.
Well, that may be where the implication tells, just like the diverting goods. If clause 4 were a precondition, then a deliberate attempt to avoid paying commission, there is an obvious implied term.
Yeah, although the interesting thing is, does that implied term come as a matter of implication from the facts or the surrounding circumstances, or is it a matter of legal principle that you can't, the parties to a contract can't rely upon their own wrongdoing to reduce the payments due to the other party? And
also comes down to the officious bystander thinking that would be...
Well, the officious bystander...
would not be part of the common intention of the parties.
Yeah, I mean, it may be that you get it out under the... But it might make a difference to the clause you were just pointing us to. Because if the officious bystander is sufficiently switched on to imply a term to that effect, it's not excluded on any footing by the terms of this contract. But if it has to be if you have to have resort to any sort of more broad principle of law, then at least arguably it's excluded by this clause we were just looking at. Anyway, those are a whole series of horrendous exam questions.
I think that
at some point you might want to pick your way through, see whether there's anything there you want to answer.
The best answer I could come up with immediately is that we're entitled, our principal entitlement is paid on the basis of what was payable and should have been paid.
Right, have we kicked this around enough, or is
my
there
lord, if you're
more?
happy that...
Well, I'm not happy, but...
Well, if you're...
I mean, I don't
if
want
you
to
don't
just...
believe that anything I can...
No, I'm sure there is, but I mean, if you've said what you've got to say, then stop, but if you've got other things to say, then say them.
My lord, ask.
Let's make one last point there in relation to whether it relates to damages. Strictly, if you apply the formula in 3.1, the less Uniserve pay is payable. In other words, if it pays less by way of damages than it would have been payable by price, you get more commission, not less.
We get more on the price.
No, because you get 50
Oh,
pence.
less, of course, it's less.
You get 50 pence per unit, less what they pay. So if they pay less, you get more on a strict reading.
I think one would have to construe it that did not happen.
No. Well, that again suggests it's not designed to cope with the situation where it's damages rather than price.
Except that would operate, yeah, I mean, if it worked that way, that if Uniserve deliberately breached the contract and pay less to high tech, you get more, because the assumption is that you're just getting a slice of what Uniserve is prepared to pay for this overall package of contracts. So is it? Well, I don't know. I mean, is it?
If Uniserve brings it on itself to pay.
If Uniserve manages to find a way of paying high tech less,
then they pay us more.
Should the commission agent be paid more? I mean, I suppose given that you were prepared to accept my lord's proposition to you, it's perhaps not obvious then that they would get paid more. But
I think
it's just not impossible as a matter of commercial rationale, but we don't know enough about the background as to how this really came into being, how the introduction came into being. I understand my Lord's question. It's counterintuitive to think that if Uniserve pay less, the agent gets more, unless you have a particular view that this is really just Uniserve saying we are going to be paying something under the contract with Hightex and something by way of commission to you. We've got a budget. And in essence, this is just dividing up the budget. If we pay less to them, we'll pay more to you. But you didn't.
I think your Lordship may have found very much what.
Well, you didn't seem quite
happened.
too attracted by that. So
What it means is that Uniserve pay more commission when they don't get the goods than when they do.
Yeah. Yeah. Okay.
All right. Well, we'll have to think about this.
My Lord, that takes us back to essentially the interrelationship between clauses 3 and 4. I don't know whether I can assist you any further on that. But clause 4 is simply mechanics. It's not stated to be a precondition. It's certainly an assumption. Providing for provision of information. It doesn't purport to create a debt.
I mean, what you're saying in essence is that if clause 4 wasn't there, this contract would sort of work perfectly well, and the court would just imply a mechanism.
Yes. And it can't be said if goods do arrive in the UK, then this mechanism will apply. But it doesn't exclude the debt arising in any event.
Right.
My Lords, it's only really necessary to look at the implication of terms in the way it's been framed until this afternoon. If we're wrong and that clause 4 is a precondition. Now, on the basis we say it was clearly the common intention of the parties that all these goods were going to be brought to England at the time that the contract was entered into. Now, if you're against me on that, then there is nothing in it. But was it really contemplated that at the time, Uniserve could take the goods, and it was just, if they happened to bring them to London, to England, then commission was payable. But if they decided to send them to France or, say, Dubai, because things might change after the contract, they could easily have found, as they did, that they could get masks more cheaply elsewhere, and maybe it would be more convenient to take them to Dubai. They were engaged with clients from China. There's nothing to stop them looking for other markets.
Isn't there a tension in the two arguments in that you say that this should be construed as mere mechanics?
Yes, so this is, if it's not mere mechanics.
Yes, but if you get to the stage where one rejects the argument that it's pure mechanics, and you construe it as being the parties did intend this to be a substantive obligation, then doesn't the fact that you can't construe it as mere mechanics cause a real problem for implying terms as a matter of business, necessarily for business efficacy, because the parties have expressly provided that this is the agreement, that this is a precondition for payment. It would be contrary to that express provision.
But they have only done so on the common intention that everything will be brought to this country. If I'm wrong on that, if there's no common intention, and you can't infer a common intention, we say if there is one, you would more naturally do it by way of construction.
But if it's but if one takes the view that it's a common intention and wasn't intended to be a precondition, then it's mere mechanics.
Yes.
So I'm struggling at the moment to see
well, it's really,
where we get what.
They both depend on the same presumption. You can either deal with it by one or the other. Now, if you couldn't construe,
You don't look at it like that.
but if you couldn't construe from its words, not necessarily those precise words, then it may be necessary to imply the term.
What's the term?
But that Uniserve are obliged to take all reasonable steps to procure that the goods come to the UK, including complying with their contractual obligation.
But then why is it necessary to apply that term?
Because the parties have made it a precondition that they do to payment that they arrive here.
But my lord's point is that if it's a precondition to payment, that the goods do arrive here, by definition, if they don't, you don't get paid. You're sort of bootstrapping yourself up on the assumption you're going to get paid, but if the parties agreed you don't get paid, because it's a precondition, then you don't get paid.
Well, no, we say that if you refuse to read the fact that there's a precondition, if that means there is no common intention, then yes, we lose.
Rather illustrates that maybe implication of terms is a part of the construction of a contract.
Well, I wouldn't gainsay.
Well, it's a bit of a heresy, I'm afraid. Post Marks and Spencer's, apparently, but anyway, there we go.
Another time, my lord. Yes, but they're essentially two sides of the same coin. We accept if you cannot read this as having a common intention, particularly from the terms itself, of course, 4.1, the complete absence of any specified condition. But in the factual matrix, where this supply contract has been entered into previously, it is a reward. Would anyone really have thought that they could avoid payment by diverting the goods? If you don't come to that conclusion, then essentially we lose on both. But what the judge didn't look at was, he looked at if you're deliberately trying to avoid paying commission. What he didn't look at was, what if they just did it for legitimate commercial purposes because it made them more money? And we say when you look at the circumstances and the words that are here, it was clearly intended and assumed that the goods would come. And if it's necessary to imply a term to do that, then so be it. My lords, I think I have been circled around my notes sufficiently to have completed all my material submissions.
Very good. Thank you very much.
We're sharing. The one over this side has one leg shorter than the other.
Oh,
Austerity wins again. I've only got one usable lecture.
well, it's good to see such cooperation.
Well, I'll deal with the Commission argument first, and then reply to really the respondents' notice points. My lords, on the Commission argument, the judge dealt with that in tab 16, page 245 of the bundle, at paragraphs 455 to 473. And you can see that between paragraphs 456 and 459, he refers to the relevant clauses of the contract, 3.1, 4.1, 5.1, 6.1 and 8.1, and concludes, looking at the wording of those clauses, that under the plain terms of the commission contract, the commissions are due only after a shipment arrives in the United Kingdom and has cleared customs. That is the basis of it, and the difference between the parties, really, is how one construes, in particular, clause 4, which we say is a condition precedent to the obligation to pay on its plain wording. The judge also deals with the question of implied terms. He refers to implication terms at 461. He rejects a general implied term, but your lordships will see that he answers the question raised by Lord Justice Mayles first thing yesterday morning. Yes, when your lordship asked me, I think if I started under the supply contract, are you obliged to bring the goods to the United Kingdom? And I said no. And you said, well, then that raises the issue under the commission agreement. And what the judge found at 462 is that there is a limited implied term, that you can't arrange for them to be collected in Jordan and then diverted to a buyer outside the United Kingdom in order to avoid making a payment under the commission contract. And in my submission, that falls within what Lady Rose described as the no dirty tricks implied term.
What if it's not a dirty trick, but you are simply able to supply your United Kingdom customer in some other way, and you choose to sell these elsewhere? Perfectly legitimate, you're entitled to do it.
Then
no commission? No commission.
There would be an argument, and I think these are the cases your lordship had in mind in the shipping context, that it is suggested that the implied term is that you will not deliberately act so as to avoid paying broker's commission, for example, on hire on a ship. But again, it goes no further. So it is limited in my submission to no dirty tricks.
I don't really, I mean, you'll have to help me a little bit. My lord may be more familiar with the whole concept of dirty tricks or no dirty tricks, but what did Lady Rose actually mean?
Well, if you want to look at the wording, she gives an example of what that would be.
This is Barton, is it?
It's in the authorities bundle, and it's tab 28.
Good example of a case decided on a point not argued, actually, because implied term was never part of the case at trial, apparently.
No, it was ever that, I suppose. So what she deals with is at 704, it's authorities page 726, or 704 of the report, and it's her we sidebarred them, paragraphs 31 and 32.
The facts, just going back to the facts, this was where if the property sells to somebody you've introduced for more than £6.5 million, will pay you a fee.
Correct. And if the issue was, what happens if you sell it for 5.5 million? And the Court of Appeal said that there would be an implied term you pay a reduced fee, and Lady Rose rejected that and said that wasn't necessary, and that it's a much more limited implied term, that you won't, for example, negotiate deliberately to reduce the fee in order to avoid the commission because there's, for example, a side fee. So she rejected the idea that if you sell for less, you get a pro rata of the commission. She said you look at what the bargain of the parties is, and they're held to that bargain. And the implication of the implied term is limited to the no dirty tricks, in the sense that you will not deliberately seek to avoid paying the commission, in that case by agreeing a reduced price. And I don't know precisely which cases my Lord Justice Nails has in mind, but the cases that, when I researched it, of course, the parties can't, in a shipbroking case, where the shipbroker is to get a commission on hire, there would suggested be an implied term, again, that you wouldn't act deliberately in order to avoid that payment, because there were cases, for example, where something was done to the hire, there was a side agreement or a dress commission or something like that avoided the hire to the broker.
Well, I was simply looking in Wilford,
Yes.
in fact, where there's a paragraph which refers to a number of cases, I'm afraid. I think one was called French and something, and another called Alpha something, but
Yes.
I didn't get any further than that.
Well, when I looked at it, it was along the lines of this proposition, equivalent to the no dirty tricks, that you can't act deliberately to deprive a broker. Unless I've missed it, I didn't see a case of circumstances where there has been a breach of contract, of the underlying contract, where that would give the broker commission, which is effectively what is being suggested in this case.
I mean, I'm just sort of slightly, I sort of obviously understand in a sense what dirty tricks means, but I'm just trying to put it into a legal framework.
So you will... Sorry.
I mean, if the vendor does a calculation, so let's go back. If the vendor can only get, as negotiating as hard as they like, 6.4 million, then they pay no commission. If the purchaser was prepared to pay more than 6.5, such that the commission would be payable, but the vendor does the maths and thinks, actually, if I sell it for just slightly less than 6.5, I'll still be better off because I won't have to pay the commission on the increased price, which would bring me down further. That, I think, is what is regarded as a, quote, dirty trick.
Yes, because you're acting deliberately with the aim of depriving commission to the broker.
No, that will be the consequence. My aim is to maximise my revenue from sale of my asset.
But with the intention of depriving the broker of his commission.
It's not my intention, it just is an unfortunate side effect.
Well,
what's the legal, sorry, I'm being provocative.
No.
What's the legal principle you attach to this? And if it's an implied term, is it it's necessary to give business efficacy to the agreement that the vendor has entered into with the agent? So that has to effectively have primacy. In other words, it's effectively the vendor has, by contract with the agent, limited their freedom to act in their what would otherwise be their own interest. Is that if we unpack the dirty tricks label, is that what it actually means?
Well, yes, but of course Lady Rose doesn't unpack it. I mean,
but I'm asking you to.
Well, the position would be that an agent accepts the risk of the normal vicissitudes of commercial life, but it doesn't take the risk of an action deliberately that has a deliberate consequence that you're deprived of your commission. So it's a question of trying to work out where the risk in the contract lies. So going back to your Lordship's example, as between the parties, the agent is taking the risk that it may not get above 6.5 as a matter of ordinary commercial negotiation, but he's not taking the risk that his client will act in such a way as to deliberately deprive him. and that's the term that it's necessary to imply, or as your lordship would say, probably comes out of the construction of the contract, if one was allowed to say that. What you're looking at is what is the risk that the parties are prepared to take as between them two. So if we go back to our contract, and the reason why you wouldn't imply the sort of terms that are being said, what the judge concluded, and in my submission is right, is what the parties contemplated here is it's common ground on the factual matrix that the intention was that the end customer was the NHS. These were goods that were going to be coming into the UK to sell to the NHS. And the clear intention, as the judges found, is that commission is only due after the goods arrive in the UK and clear customs. Because if you look first of all at clause 3, when it refers to the goods in that shipment, the reference to goods in that shipment is not a reference to nominal shipments identified in 1.2. That must be actual goods in the shipment. It's not on the 28th of April, one assumes there has been a shipment of 6 million units. It must be the total number of goods in that shipment. So, for example, your lordships have been referred on a number of occasions to the table in the core bundle at 109A, and your lordships saw that originally only 1 million masks were shipped against the 5 million. So what 3.1 is looking at is the actual number of goods in that shipment. So if, for example, high-techs were meant to deliver and then ship 5 million masks, but in fact they only deliver 1 million and only 1 million get shipped by Uniserve to the UK, the reference to goods in that shipment must be to 1 million. That then has to be, that gives you the A figure. B is equal to the sterling equivalent of the total amount paid to the supplier for that shipment. So that's the total amount paid for the 1 million masks. But then one's got to take the sterling equivalent, and one then goes over to 4, and in my submission, the natural reading of 4.1a is you take the exchange rate on the date it's cleared customs. And clause 4 is not merely an invoicing mechanism, it is setting out the circumstances in which payment is due, and it works backwards. So 4.5 is Uniserve shall pay any such duly invoiced amount within 2 days of receipt. But you can't get an invoice until it's issued, and the introducer is only entitled to raise an invoice under 4.2 after it's received the fee schedule, and the fee schedule is only issued in 4.1. Uniserve shall produce a fee schedule after clearing customs. So it works then going the right way round. The goods arrive, they clear customs, then Uniserve shall, mandatory, produce a schedule which gives the exchange rate, which must be the exchange rate on the day of clearance, and the number of units in the goods applicable shipment according to the information supplied by provided by the supplier. So the supplier will provide a packing list or an invoice. When those goods have cleared customs, Uniserve will do the calculation of that number with the exchange rate on the date of clearing, and that's mandatory. And only when that has been done, in 4.2, is the introducer entitled to raise an invoice. It's not a question of a mere formality. He's only entitled to raise that invoice once he's received, after he's received the fee schedule, and then once that invoice has been raised, Uniserve shall pay. So it's a mandatory provision that provides the circumstances in which Uniserve is obliged to pay the agent, all based on the goods that have arrived and passed customs. And that's why 5.1 to 5.3 works, and my learned friend had so many difficulties with it, because what that's really dealing with is you get the goods past customs, you then inspect the goods and you find packages missing or you find they're defective, so you either reject them or that, and you can see 5.1 is mainly looking at rejected goods or defective goods, and it does say or for some other reason. But it's...
Why do you say that would be after they clear customs?
Well, that's not... all I'm saying is that normally what would happen is after you've cleared customs and you've inspected, you reject goods because they're defective, because you haven't seen them until then. That's why 5.1 is working in that way.
But that would be for goods that were being shipped to you in the United Kingdom. Yes. These goods are delivered and accepted in Jordan.
Well, it could happen you inspect them there. It's more likely to probably inspect them in the UK. But it is, yes.
Well, in fact, I mean, the risk of damage to them or them becoming defective is in Uniserve's hands as soon as they're made available or collected in Jordan, I think.
That's true. So I may be mistaken about that. Then it could happen. It's whenever you inspect them. I mean, this is dealing with whenever you inspect them, and there's a dispute. But the main point is clause point. I mean, the main difference between the parties, and it's a short point of construction for your lordship, but the judge found that the purpose of 4 is to identify the payment obligation, and that the focus of 3 and 4 is receiving the goods in the UK. And we submit that 6.1 is important because it says the introducer acknowledges that this agreement doesn't represent a commitment by Uniserve to purchase any goods from the supplier. And all that's saying is, as between us, there's no obligation. I'm not in breach of any obligation to you, whatever happens under the contract. Otherwise, 6.1 is meaningless.
So, could Uniserve, I mean, you see the schedule at clause 1.2, and let's say, take the second date to freeze of 5 million units on the 5th of May. Could Uniserve agree with Hightex that instead of 5 million units, actually on the 5th of May, I only need 1 million units, and then that's shipped, and those are shipped into those are imported into the UK.
Well, that's what happened.
Okay.
I mean, if you think about it, one of the only point we were making in the skeleton on the you can't change this contract without a written change was you can't treat these shipments in this contract as nominal shipments that whatever happens triggers the commission, because of course what actually did happen was that they were unable to ship 5 million for that first one. They only did in fact ship 1 million, and if you look at the pleadings, the commission was paid on the 1 million. So the dates were in fact changed. And that's why I say in 3.1, the reference to goods in that shipment means actual goods.
Okay, so I am Uniserve and I know that I can get face masks or face masks and I can get them more cheaply elsewhere. So am I able to reduce the volume that I agree to buy from Hightex freely and at my own will? And if that's the case, how do you distinguish that from the dirty trick situation?
So the position under this contract is that if you construe it that there is no obligation under clause 0.6 as between them to buy any Uniserve and Mr. Popek and his company to buy any particular amounts, then the answer is yes, you can. In which case, if you conclude that that's what you can do under the contract, as my Lord Justice Phillips said, once you've construed what the contract means, there's no grounds for, it's not a dirty trick. If the bargain is, I will pay commission on what I get in the UK, and for some reason you choose in the end not to pursue with the sale contract, clause 6.1 it says that as between these parties, that's the risk that Mr. Popek has made. Because what's being intended is that it will be the goods coming into the UK.
Yes, and that is.
I'm just asking for a reference. I think it was a point that my learned friend made, is that Mr. Popek was the representative of Hightex. And so if Hightex agree to take less, it's their representative who's not getting the commission. So it's different from the.
Sorry, I think I'm not sure you said that correctly.
I think I have. Well, that's why I'm. Oh, so if you go to this,
he was Hightex aid. He was Hightex
representative.
You said if Hightex agreed to take less.
If Hightex agreed to give less,
sell less.
Sell less. And what your lordship was putting to me was, what if Uniserve and Hightex agree, for whatever reason, that instead of 80 million under the contract, there'll only be 1 million. I think that's what your lordship was suggesting. And what I was saying is that this is a slightly unusual situation in that Mr. Popek isn't our representative, he is Hightex representative. So if they choose to give less, they're doing it in the knowledge that presumably that their representative will get less commission. Because if you look at the supply contract, page 403, Mr. Popek is the supplier's authorised representative. So it's different to the sort of position that Lord Justice Miles was putting to me. He's not an independent broker. He's in fact Hightex's, or the seller's, designated representative under the supply contract. So if Hightex agree less, they're doing it presumably knowing that their representative will not get paid the same commission.
Yes, I mean, what we're actually dealing with is not so much what happens if the Uniserve decide to send the goods elsewhere, or even if they agree to take less, but what happens if they fail to take goods which they should have taken in breach of contract, so as to give Hightex a claim in damages. So as I understand it, that's the only circumstance in which the commission claim runs, unless I've missed a point somewhere.
No, and my submission is, one, on the true construction of this contract, the right to commission only arises when the goods arrive in the UK on its true construction of clauses 3 and 4. Therefore, if there's a breach of contract by Uniserve, the goods do not arrive and they're not entitled to the commission, and that is the bargain that has been made. 2, a breach of the supply contract does not and is not contemplated as giving rise to any claim for commission or damages in lieu of commission, because of clause 6.1, where the parties recognise that the commission contract does not obligate Uniserve to purchase anything under the supply contract. 3, the other point that was made is under clause 8.1, the commission contract will terminate automatically, that the supply contract terminates, quotes, for whatever reason. So if Uniserve are guilty of an anticipatory breach and it's accepted, the supply contract terminates and the commission contract terminates as well. And so this is a very simple contract for commission.
That, I suppose, may be one reason why Hightex may have thought it suited them to keep the contract open for performance, so they could say it hadn't terminated.
Possibly.
I don't know whether they would have thought in those terms, but that might be the consequence.
Yes. Well, and if Mr. Popek is their designated representative, they might choose to do that. And of course, that might be right. But the point that the judge also made is what the parties have agreed, the bargain they've agreed is if the supply contract terminates for whatever reason, which presumably includes an anticipatory breach that's accepted, it brings the commission agreement to an end. It's not suggested in those circumstances that that is a breach of the commission agreement. And again, that's because there is no obligation between Mr. Popek and Uniserve for Uniserve to comply with the terms of the supply contract. And in my respectful submission, the whole thing really turns on the construction of the contract. If I'm right that that is the bargain the parties have made, the only implied term is the dirty tricks implied term. That there isn't some other implied term for damages. This contract doesn't deal with damages. The commission isn't triggered by damages.
Well, I mean, if you're right, certainly on the last submission, even if Uniserve take the view that actually it's in their commercial interest just to breach the supply contract, just to not take anything, and high-techs take what might be thought to be a conventional approach of saying we accept your refusal to take any as terminating the contract, then the commission agreement just falls away and no commission is payable.
Correct.
And so, in a sense, the dirtiest of all dirty tricks, just a flat refusal to perform by Uniserve, is that just, I mean, in a sense, there's no dirty...
Your Lordship was probably quite right to ask me, well, what does dirty tricks actually mean?
Yeah.
But because the point is that the dirty trick is as between the agent and the principal. If under another contract you decide to breach it, if the terms of the contract are I'm only paying commission on stuff I actually get, there is no dirty trick vis-a-vis the agent in those circumstances. And also you've got to look at the circumstances of this case. I mean, we keep talking about dirty tricks. What the judge found was that our two terminations were incorrect or wrongful on the 17th and of the 11th, and that was therefore an anticipatory breach. And that's what he's found here. And the question is, if you take a view that you were entitled to terminate but are wrong, obviously that will have a consequence under the supply contract. But it's difficult to see why that should actually mean you pay more commission to someone for something you never get. And that's why, what was the aim here was, we will get these goods in the UK and we'll pay your commission on them. And if you conclude that that's what it is, there's no room for these wider implied terms, because it can't be an implied term that you will buy anything under the supply contract, because 6.1 excludes it. It can't be an implied term that post-termination some obligation to pay commission continues, because 10.1 says that it ends. So that's why we say the judge was right. In my perspective, it does turn on a question of construction of the contract. There is no room for some implied term that you will do something else. If the position is you've agreed to pay commission if it arrives, and it doesn't, for whatever reason, including a breach of the underlying contract, you're not liable. And it goes back to the shipping cases as well. If you're paying someone commission on hire, but for whatever reason the contract comes to an end because of a repudiatory breach, you don't pay any further commission. The broker can't then turn around and say, well, you broke the underlying contract, I'm entitled to my commission I would have got, unless there's some express term to that effect. I mean, if you were to imply something wider, you are, in my respectful submission, going contrary to what Lady Rose was saying, that you are putting you only allow a very narrow implied term. Now, what my learned friend is saying is the implied term is, I will comply with the supply contract. That is the implied term in its nutshell. The implied term is I, Uniserve, will perform the supply contract. And if I don't, I will pay you damages. And there's nothing in here that says that.
Can we just examine your fundamental proposition, which is that clause 4 isn't merely mechanics, but is a precondition of payment?
Yes.
Just looking at clause 3 for a moment, it's headed commission and says Uniserve shall pay, which shall be calculated as follows. I mean, do you accept that that on its face, I think as my Lord put it, is on its face, before we get to clause 4, a full and complete and on its face enforceable obligation to pay commission, which has nothing to do with arriving in the United Kingdom?
No, because you can't have a sterling equivalent. You've got to work out what sterling equivalent you're talking about.
Why can't you?
Well,
why is it any clearer in 4 than it is in 3?
Because 4 tells you when you work out this.
It doesn't.
Well, in my respect for mission, 4. Well, let me get back.
It doesn't make it any clearer at what date in 4 than it does in 3.
Well,
what date in 2?
I would submit, if you take that view, then your lordship's right. But I would submit that if you look at 4.1a in its context, if it's talking about exchange rate applicable, and you're issuing it on the day after it clears, a reasonable person would read that as relating to the clearance date.
Well,
now,
it says pursuant to clause 3.1b, so on the face of it, it's whatever is applicable in 3.1b. So I don't think it can help. That can't help you. It can't be any different to what is applicable under 3.1b because it says so.
But if you look at the words exchange rate applicable pursuant to clause 3.1b, and you go to 3.1b, what it's talking about is the exchange rate equivalent of the total amount paid by Uniserve the supplier. So B is talking about the amount paid, and then you have to apply an sterling exchange rate to it. And the question is, when is that sterling exchange rate? And in my submission, it can only be, on 4.1, the date of arrival.
Well, no, I think it's the date it's paid.
Yeah, I was going to say, I was going to do a tag team here. Well, if you look at the supply contract, Uniserve will pay, is supposed to pay when it collects the goods, isn't it, on delivery?
Yes.
And so, if you're looking at the most obvious date to select under 3.1b, you'd select the date on which Uniserve pay.
Otherwise, it's also the date that matters, isn't it?
There's a currency risk. Otherwise, of the exchange rate shifting between the day on which they picked up the goods in one jurisdiction in Jordan and brought it back, and eventually managed to get itself through customs in the middle of COVID, with the exchange rates bouncing around all over the shop.
Well,
why don't you just read 3.1b as the amount when the goods were collected and payment should have been made? That's my lord's point.
I understand the point, and I've submitted the opposite. But like all these questions of construction, those are the two arguments. My submission is read naturally. One reads 4.1a as relating to the date of arrival in the UK, but I see the other argument.
Let's assume that it's one or the other on either event. Just trying to understand why the parties would have made a precondition without. It could easily have said in 3.1 paid to the commission, which should be calculated for each shipment which arrives in the United Kingdom, and that would be the end of any argument, wouldn't it?
Well,
and I know you can always say, well, if that had been said, we wouldn't be having the argument. quite. But
But you could always draft anything better. The problem is this is what you've got.
no, but the thing is, this is the one which is the one-headed commission, which appears to be creating the liability to pay commission. And it's quite easy, isn't it, to read a further provision which sets out the mechanics for how the matter is dealt with administratively to give effect to what is in the decree as mere mechanics.
It's possible to do that, but in my submission, that's the wrong construction of this contract.
Yeah, I'm just asking you why.
Because you read the two together, and as I've already submitted, the mechanics in 4.1 to 4.3 are all using words shall.
And mechanics can be mandatory, can't they?
Mechanics can be mandatory, but in my submission, it's not merely a mechanic, it is actually giving rise to the obligation.
I was wondering whether the obligation in paragraph 2 might have some impact upon customs, such that you wouldn't know that that obligation had been met until the goods have cleared customs. But that's just speculation.
Well, I suppose what your Lordship has in mind is subparagraph C, for example, where you're talking
And
about
D,
it must meet
and
EU.
D.
Well, it's the EU regulations in C, and then D, declarations of conformity.
And examination certificates.
Yes, because they're EC type examinations. But that is possible.
It's just very difficult on its face to understand why on this agreement it suddenly it would introduce a condition that the goods have to arrive in the United Kingdom for you to be liable for commission, and that's the only thing I could think of as to why that might be the case. There was no evidence or argument about that.
Well, the only discussion was, of course, that this is all against the background that this is an on-sale arrangement to the National Health Service, and that what Uniserve want are goods in the UK that they can sell on to the NHS. So if they arrive in the UK and, for example, on inspection they don't meet the type examinations or they don't meet the PPE regulations, then they're useless.
Has anybody looked at those regulations? Because unless I misremember them, I don't think those regulations purport to prevent or have anything to do with whether they clear customs or not.
Mm.
It's a question that they are questions of whether they can be sold within the UK or supplied or used within the UK.
Yes.
So it's not the customs. I mean, customs don't check the face masks for compliance with any standard or otherwise. Do they?
I'm not sure.
Sorry, go. Sorry.
I'm not sure who's asking what question.
Sorry, I probably jumped in and.
Well, I was asking whether or not my Lord's point, my Lord, I think, is answering is in the negative.
Well, I don't know whether anybody has read those regulations, but I think I have some vague recollection that those types of regulations are all to do with what you can do with products in the UK, not whether they clear customs.
That might be right. But the point is, until they get into the UK, what Uniserve want are goods in the UK that they can deliver and give to their customers, the NHS.
But that doesn't work because your obligation under the supply contract is to inspect the goods as soon as possible. The thing to stop you inspecting them in Jordan to see whether or not they meet EU standards.
But what all we're looking at is how does this contract work? And are there reasons why? What your Lordship put to me is why would it matter that they're in the UK and clear customs? That was the question Your Lordship put to me.
Yeah.
And my answer was, because what Uniserve want are masks in the UK that they themselves can deliver to the NHS.
So they can ensure that in Jordan.
But unless and until they're here, they can't give them to the NHS. Well, if for example, they're in Jordan and the government requisitions them before they leave. I mean, there were examples during COVID of countries not allowing the export of PPE. I mean, there were quite a lot of examples of that. That was one of the problems early on, that although the UK had a lot of supplies from countries like China, we couldn't get hold of them. And I think my Lord Justice Snowden said you couldn't get hold of them for love or money.
Well, if that was a genuine concern and consideration in these agreements, you'd have put a term about that in the supply agreement.
Not necessarily.
Otherwise, you'd be liable to pay for the masks.
Well,
you wouldn't have to pay commission, but you'd have to pay for the masks.
yes, but Your Lordship's asking an awful lot of questions where we don't have witnesses to answer them.
Just trying to understand if you've got an answer to why it would be a condition they reach the United Kingdom.
Well,
Exploring.
Yes, I understand that. And I try to answer by saying, because what Uniserve were a logistics company that had got a contract with the NHS. It wasn't normally a buying and selling company. It had this, but in order to ensure that it could pay, it had to get the goods here. It therefore makes commercial sense why there is a reference to clearing customs for the commission agreement. I do not know why the same didn't apply in the supply contract, because I don't know what the negotiations were, but it's interesting that the supply contract was not a CIF contract and not an FOB contract, not an arrived contract, but an ex-works. And that's what they agreed for the supply contract. But there still is a commercial reason why you wouldn't, and they may not have been able to get some other contract. We just don't know. But if you're asking, is there a commercial reason why Clause 4 would focus on clearing customs, my answer would be, yes, there is, because Uniserve want to ensure before they pay commission that they don't have to do it unless it's clear customs. Why they couldn't get the same under the supply contract, I can't assist you, Lordship. I'm just reminded that, but I'm not sure it really answers your Lordship's question. Under the supply contract, High-Techs were obliged to make sure that they had all the consents and all the things. So your Lordship's right, they could be inspected in Jordan and you could say you're in breach of the supply contract. But your Lordship's right about that.
Well, in fact, 2.1D clearly suggests that actually the introducers had to ensure that all the various documents, I think, declarations of conformity and approvals, etc., are in place prior to the delivery of any goods to Uniserve.
Yes.
So that it suggests actually that quite a lot has to be done long before they get anywhere near the UK.
Yes, I don't dispute that, and of course that must be right. Because, but Uniserve obviously want goods manufactured that will comply, but equally they also want the goods in the UK to give to the government. My lords, I think we've probably been around the houses on that.
Is that the commission agreement?
Yes. What I'm going to focus on, and I imagine your Lordship wants to finish this afternoon.
Well, if we can, but you must say.
I will do my best, but your Lordship's raised a number of questions on evidence, and I would quite like to just make sure your Lordships have got all the relevant evidence you need. But I will do my best. I'm going to focus then on first of all the respondents' notice points, and just stepping back, the proposition that your Lordship's been asked to accept is I kept the contract open. I only ever had 15 million or 20 million masks, but I'm entitled to damages as if I had available or supplied 77 million. And in my submission, just as a matter of common sense, that sounds remarkable and incorrect. If you've chosen to keep a contract alive which requires a cumulative total of 80 million masks, you cannot possibly claim damages for 80 million or 77 million if you have only ever got available 20 million. And the answer to the whole conundrum is, I think as I started in opening, and my Lord Justice Snowden commented, it's common ground that the figure in the contract is a cumulative total. It's agreed that the contract is cumulative. It's also been found by the judge and not appealed that it is not a severable contract. It is a cumulative whole contract. Thirdly, again, I think a point my Lord Justice Mayles made, when you have a repudiation or renunciation, you have one choice of two possible paths. You can either bring the contract to an end, or you affirm or keep the contract going. What you cannot do, which is one of the points that my Lord Justice Phillips made in the estoppel argument, is approbate and reprobate. You cannot say, because of your breach, a thing written in water, which I do not accept, I am somehow excused from my obligations under the contract, because that is a different contract. And that is the problem with my learned friend's retendering argument. Although it's called a retendering argument, as was clear during the arguments before your lordships, it was not a case of actual retendering. This was not a case where this actually happened. This is not a case where on each of the dates in the contract, goods were offered. This is a legal construct after the event to try and justify damages that do not flow from the breach.
I thought the case on retendering had effectively morphed into an argument that they had they were discharged from each instalment as it was not collected.
Yes, that seemed to be the new argument. But again, that can only be right if, one, it is a several contract, and two, they somehow accepted the rejection. I mean, it was, I don't mean to be rude, but it did move quite a lot, this analysis. The only way this could work, and this was, I think, one of the debates with your lordship, was they would have to somehow bring to the end that instalment. There was this whole debate about under section 27 and under section 50. If you wanted to claim damages for that instalment, you'd somehow have to say, your failure to take these goods is a rejection of that instalment. We accept that rejection to bring that instalment to an end, and we can claim damages for it. But that would only work if it was a severable contract, which it isn't. it isn't, your lordships, I invite your lordships to just look at their pleading. It is not in their pleading, nor was it submitted at trial, that any rejection was accepted and brought to an end any particular instalment. That wasn't...
They accepted that, and they accepted it's not in the respondent's notice either.
Correct. But if you haven't done it, how can you say you are excused from the obligation to perform? And your lordship puts to them a particular example of, say on a particular day they don't turn up, but time is not of the essence. How's that obligation brought to an end? I think the answer was, well, you would have to make time of the essence, and then you'd have to accept. I mean, the only way you could do it, assume it was a several contract where time is not of the essence, is they don't turn up on that particular day. You then have to serve the notice-making time of the essence, and then say they are in breach, they have not accepted, they have rejected. And that's really the section 27 point.
What about section 37? Perhaps you haven't looked at it either.
Section 30, yes. Bear with me a second. Section 37 is set out in our skeleton argument. It's in the footnote to a skeleton argument, in the core bundle, tab 12. At page 145, that section 37 is at the bottom there. When a seller is ready and willing to deliver goods and requests the buyer to take delivery, and the buyer does not within a reasonable time after such request take delivery, he is liable to any loss occasioned by his neglect or refusal to delivery, and also for reasonable charges for the care and custody of the goods. But you've got to have a request to take delivery. And as we point out, A, they don't do that, and B, it's the loss occasioned by his neglect or refusal to take delivery and reasonable charges for the care and custody is not necessarily a section 50 damages. You'd only again get section 50 damages if you can treat it as a severable contract and you bring that instalment to an end. But it's common ground that didn't happen. It wasn't suggested at trial it happened, and it's accepted before your lordships that this is a contract which is not severable. And so the whole thing collapses. And my lord, Mr. Lewis suggested quite often that the problem was this all developed out of the blue and therefore was not properly focused on, and he explains that's why he says the retendering argument only came at the end of the trial. But I showed your lordship, and I'd just like to remind your lordships that we clearly pleaded that we put in issue. Their allegation was that they had sufficient material for each instalment, and we denied that. If we look, please, at the core bundle, tab 24, at page 25257, sorry, 357, 19b, Hightex had available sufficient quantities of goods to to meet each instalment as it fell due. That was the plea. Uniserve refused to accept any further instalments and to fail to procure Magellan was at the factory at each subsequent agreed delivery date in order to accept and collect such delivery. And if you then go to the next tab, tab 25, at page 376,
Paragraph 90B, the one you showed us yesterday.
yes,
Or maybe 90B.
90B, we deny the first sentence and we point out that they did not continue to manufacture units in respect of the supply contract after mid-July 2020. So it was very fairly and squarely put in issue at the trial. And my learned friend kept saying, oh, if it had been an issue, we would have pleaded a reply. You will look in the reply in vain to find anything about, quote, retendering, or anything about any of the subsequent previous instalments. And I will come back to this in due course, but one of the oddities is that my learned friend yesterday started by saying, well, if you think that grounds 1 and 2 succeed and you dismiss the respondent's notice, he says, I would still win on earlier instalments. Now, I strongly object to that. There was never a pleading that he was in any event entitled to the earlier instalments. When the issue at the trial was that we had terminated on either the 17th of June or the 11th of July, it was never put to the judge that there was a breach in respect of earlier instalments, let alone that they brought them to an end and could retender. So there are no findings for your lordships as to which instalments we would be liable for in those circumstances. If that point had been alive at the trial, in my respect submission, there would have been a lot more focus and debate in respect of each of those instalments as to what the obligation actually was. You have the additional problem. You're being asked, my learned friend is saying, well, you can find which instalments we're still entitled to claim for, when that wasn't found by the judge, wasn't raised by the judge, wasn't pleaded. And then what damages are you going to apply? Because the judge has found a composite figure for the 13th of July. But on this basis, of course, you would be looking at figures, for example, in a breach in June, which wouldn't be the composite figure. And the only material that you've got available is our expert report, which I showed you yesterday, which shows, for example, in June, the market rate was 45, which is above the contract price. None of this was argued before the judge. And as a result, that's the reason, or one of the reasons why there was no focus on the idea of we brought the contract to an end, we brought earlier instalments to an end. It just wasn't part of their case. And in my respectful submission, this is a case where if you shoot for the stars, if you claim the full amount, which is what they did, and you fall short, you don't get a smaller sum unless you pleaded it. And the Senate Electric case, which is in the bundle, at tab 13, we could just very briefly look at that. It's tab 13. Authorities Bundle 312. And this was again a case where the judge rejected the damages calculation put forward, but put his own calculation. And if we go to page 312 in the Authorities Bundle at page 435, if I could invite your lordships to just read paragraphs 50 and 51, and then 53 and 54, please. So this is a case where, if you look at their pleadings, they claim 23 million. That's what they claim at trial. They didn't claim any sub-installments, which is probably why they didn't focus on this issue of termination. And in my respectful submission, it is too late to invite your lordships to help them out without a careful analysis of which instalments they would be claiming and how much would be available. Then final on this before I turn to the, just briefly on the estoppel. My learned friends say that their claim is under section 50, subparagraphs 1 or 3. And as my Lord Justice Mayles asked, well, how does that work when time isn't of the essence? Because until you've made time of the essence, you can't say that there has been a refusal or non-acceptance to fix the time for calculating the damages. Because again, it goes back to what my Lord Phillips said. Well, if time's not of the essence and they don't deliver it on Monday, you can't go out Monday afternoon and sell all the goods because they can turn up on Tuesday. So unless and until there has been a refusal because time has been made of the essence, or they expressly say they're not taking the goods, you can't trigger a claim for damages under section 51 or 53. Well, then the estoppel argument. Just a couple of points. One, again, not pleaded. Two, not run at the trial. Three, therefore no findings by the judge on either representation or reliance. And my learned friend showed you again in the authorities bundle tab 10, Simona, the Furka Metal case. And from my note, I think he showed your lordships page 805 F to H on how Mr. Boyd was going to put the estoppel argument. But I think I drew your lordship's attention if you go to authorities page 253, page 806, the fifth line down, that the judge, of course, rejected Mr. Boyd's submission because there was no finding of any such representation, let alone that the owners were induced thereby not to make the vessel ready to load, which was, I think, the point my Lord Justice Mayles put where in the evidence do I find an unequivocal representation or an acceptance of it and a reliance on it?
Yes, you did draw our attention to that.
And
Just another more basic point is that if this point were to be run on the basis that it was now wanting to be introduced, wouldn't we have to be provided with a draft pleading?
yes, you would. We'd have to work out what it was going to look like. And just the fine, yes, we would.
I mean, apart from what's said in the skeleton, I don't think it's framed, formally framed anywhere, is it?
No.
It's not in the respondent's notice either. So
No. The first
I'm
time.
not sure where the meat is that we would be able to hold of.
Well, I asked Mr. Lewis to formulate the representation, and he had to go on his feet. So the transcript will show what he said.
Yes, and your Lordship's had my submissions on that. What is the representation? How can you formulate from I will not perform the contract a clear and unequivocal representation that you are entitled to continue performing the contract but not manufacture any goods? It's very difficult to see what is the representation. Certainly you would need it pleaded. And one of the oddities, if we go in the supplemental bundle, please. If we go in tab 6, please, and we can see at page 77, this is the skeleton argument of the claimants for the trial commencing on the 13th of May. And if we then go to page 102, paragraph 117, oh, sorry, I'm reminded this is under a section at page 99, headed termination. That's what he's dealing with. And then at 106, it refers to the letters on the 11th of July. And then it goes through various points. And then at 117, it said, even as later the 11th of July, Uniserve by Dr. Stead was claiming that the supply contract had not been terminated but abandoned such that both parties work away. In sum, there was no clear and unequivocal communication. Your Lordship sort of seen from the judgment that what was being suggested was there was no clear and unequivocal communication by Uniserve terminating the contract. So if there's no clear and unequivocal communication, how can that amount to a clear and unequivocal representation that they were not to, that they could perform the contract but not manufacture any goods? It's an impossible position. Now, my Lord.
Well, the judge seems to have accepted that, actually, because I think I picked up with Mr. Lewis the paragraph of the judgment where the judge went on to say that the position was confused until the 11th of July, and that's the word used in paragraph 118.
The only difference, the only subtle difference there, my Lord, is the judge found up until the 11th, the submission was even on the 11th. If you look at the way
yes.
reads 117, 118, they were saying at trial that there wasn't a clear and unequivocal termination, even on the 11th, having referenced in this section of 106 the two letters. And the problem is, without the estoppel, if you take the estoppel out, the retendering argument falls away. So I was then going to deal with the ground 4, unless there's anything else on 1 and 2.
Yes.
I think I will be able to do this if you're able to sit till 4:30. I might be able to do it earlier, but I imagine your lordships would prefer me to finish today.
All right. Well, we can sit till 4:30, but we will need to finish at 4:30.
Yes. If it looks as though I'm not going to finish, I'll tell you at quarter past.
If you're not, if we need to come back for half an hour in the morning, well, we'll have to. If we can avoid it, it's better.
I'll try not to. It's just your lordships asked quite a number of questions.
Yeah, just confirming, we will need to stop at 4:30.
Yes, and I wouldn't go on. Your lordships asked quite a number of questions about the warehouse structure. I think my Lord Justice Snowden asked about, is it all in one building?
Well, I think we've found the evidence that it is. No, it's not, you say.
Well, I'm going to show you. I'm not sure it is. I'll show you in a second. And I think my Lord Justice Mayles asked some questions about was there evidence of actually how deliveries worked in practice? Were invoices and so on actually issued? So those are the two topics I was going to just show you the evidence so that you've got it in front of you because you asked those questions. As far as the position on the warehouse is concerned, if we go please to Mr. Kandara's witness statement, which is tab 22 of the bundle. His evidence at page 357 he says, paragraph 19, at that time we had two buildings. Part of the production was in one building, and about 100 to 200 metres away, we had another larger building, which Hightex had rented to prepare for the new machines as part of Hightex's expansion. And then he says, at paragraph 27 on page 359, at the time when we signed the supply contract, we had a main storage area on the ground floor of the main building. And in paragraph 39, ready goods were initially transferred to the warehouse inside the building, but after some time when we started to have more and more ready goods produced, we needed to rent some additional warehouse space. It was not in the same building as the factory, but it was in the same area. So I'm not sure that it is right to say everything's in the same building. There seem to be two buildings and goods moving between the two.
The delivery was at a named numbers building, wasn't it?
Yes.
27.
Well, it's in the supply contract, it identifies a particular building, but it seems that some of the goods are in another building. They're not all in the same place. And then your Lord come straight on to your Lordship's point about what happened in practice. Mr. Kander deals with that at page 361 in the next section, Hightex processes for deliveries. Once a shipment was ready for delivery and inspection, we would prepare a commercial invoice and a packing list. We had to request a certificate of origin from the Chamber of Industry, which could be done online for any export. Once we received the certificate of origin in hard copy, we then had to take it, the invoices and the packing list, to the Jordanian Food and Drug Authority to get it stamped and get a license for exporting. Once we submitted the documents for export, we would usually pick up the approved and stamped documents on the second day. We needed to know quantities being shipped before we could get permissions. This was because during that time, the government in Jordan had announced that exporting or re-exporting PPE was not allowed, but Hightex was able to get an exception because there was an opportunity for the medical industries in Jordan to export with the UK. The quantity and the export permissions needed to match the invoices in a booking for a flight. And then, so rather as one would expect, I think what your Lordship asked Mr. Lewis yesterday is, Uniserve's agent couldn't simply go to the factory and say, I'll have this, this and this off the shelf, could he? And I think it was suggested that he could. But in practice what happened, looking at this, is that obviously they designated particular boxes for the contract. they had to issue an invoice and a packing list. They had to apply for a certificate of origin, which presumably means you have to identify the boxes, and you had to go round to the Jordanian ministry before you could get an export license. And it's only once you've done all those things that your goods are going to be ready for collection and delivery. And that's what he then says. He then deals, if your lordships want to understand it further, at 363, under first shipment. And he says in paragraph 47, I recall telling Magellan that the first shipment was ready when we initiated the invoice and packing list. The invoice and packing list for 6 million was sent to Mohammed to send on to David in Uniserve. I told Magellan that when we were ready to collect, we needed to initiate some documents to obtain the permission required. And then at paragraph 65, delivery of shipments, he says, on the 31st of May, the second shipment was ready, and I sent an email to Mr. Adjan to inform them that we were ready for inspection. And I also sent the invoice and packing list to Mohammed so that he could pass it on to Dr. Stead and David for payment. And then at 70, he says, I was in regular communications with Sajaf and Magellan, and following initial communication, I recall the majority of communications taking place by phone. Sajaf would ask in general terms about the shipment she was willing to collect, whether it was ready or not. So I was telling it that we were ready because we were. So, and then
it looks from paragraph 42 in particular as if once the masks are manufactured, it takes at least 2 days, let's say 2 days, for them to be in a state where they are available for collection.
Yes, that's correct. So this isn't a case where you go to the factory and say, I'll have those three from that particular shelf. You have to go through this process before they're ready. And what this all suggests also is when they've done that, High-Tech's contacted the agent to tell them, we're now ready, which is what you would expect. And if one then looks at High-Tech's own closing in the supplementary bundle tab 9, at page 212, paragraph 80, dealing with the second shipment, it said, which should have been collected on the 31st of May, was not collected on the 10th of June because of lack of flight availability. And then he sets out all the evidence relating to that shipment. You can see pleading witness statement, cross-examination. But if you go over the page, you can see under D2, contemporaneous documents, packing list, an invoice, and an email from High-Tech to Magellan saying, we're ready for goods inspection. And if you then go to 215, you can see for the third shipment, at 216, little 2, again you can see the contemporaneous documents, email High-Tech to Magellan, requested quantity will be ready on the agreed date, and then it's confirmed that they'll come and collect, and then you see the packing list, the invoice and the delivery note. So, really, much as your lordship rather suspected in his questions, it isn't a question of people just turning up and picking goods up from the factory floor. It goes through a process at the factory over a 2-day period to get the right goods, in effect appropriating them to the contract, and then High-Tech's notify Uniserve's agents that they're ready for collection. So that when your lordship asked the question yesterday, what was the evidence? That in my submission is the evidence of what happened for the earlier shipments. And of course, the judge picked up the significance of this because when he incorrectly was looking at did High-Techs accept the renunciatory breach, one of the things he thought was striking was that High-Techs no longer were informing Uniserve the goods were ready for collection. And that's because the evidence had been at the trial beforehand that that's exactly what they did do.
Is it necessary for, in order to demonstrate that the goods were ready for collection, to be able to say or show that certain goods had been appropriated to the particular delivery?
It's not necessary. You would have to show which goods were going to be available.
How can goods be ready
Well,
to be collected if they haven't been appropriated?
Let me go back. You would have to, maybe the answer to your Lordship's question, I was too quick, is yes, because you would have to go through the process of showing that you've issued your invoice and your packing list and obtained the permission from the Jordanian government for the export.
Just to export those particular goods?
Yes. And in order to do that, you'd have to identify those goods.
And if they haven't terminated the contract or accepted the repudiation, they would have to do that for each and every instalment.
Correct. Correct. And if they don't do that, they can't claim for the price of those goods. And of course, in order to do that, they have to manufacture the goods.
Well, and you cannot fail to accept or reject goods which haven't been appropriated to the contract.
No, you can't. On the facts of this case. So then that leads on to the 15% point. I've shown your Lordships the evidence that relates to it. We've looked at it twice now. I'm not going to go back through all of it. But the starting point is Mr. Kedar's own witness statement at tab 22, page 362, paragraph 42. It was his own evidence that, in fact, they were reserving 15%. That's his evidence. And when my learned friend put to your Lordship, well, when you look at the cross-examination, it's inconsistent and contradictory. In my respectful submission, that's not a fair way of reading that passage that you've now looked at twice. He accepted paragraph 42 until the judge asked him a question where his answer was contradictory. And then what Mr. Walsh did immediately after that was remind him of what his witness statement said. And he accepted that his witness statement was correct. And then when you look at the other cross-examination, as my Lord Justice Mail says, the gist of that is we were keeping 15% back in fact. And my complaint about the judgment, and I think I said this yesterday, is nowhere does he deal with that. It's said that tangentially in that one paragraph your Lordships were shown, he must have been rejecting it. But that's because he's put the two, the requisition and the 15% together. And he has not focused on the fact that it was High-Tech's own evidence that they were keeping 15% back. Nowhere does he deal with that particular point. And once you do that, you have to look again at the tables. And if we look just again at the judgment in tab 16,
336 or something else?
Beg your pardon, my lord?
Paragraph 336 or
336. Well, it's first 334.
39.
This is under the rubric the evidence from the production reports and delivery notes. And the problem was at 334 he'd only gone up to the 14th of June. He then in 336 dismisses the points that were made. But little 4, our complaint in little 4, is that he doesn't deal with the 15% point expressly, and he doesn't refer to the evidence he was given. And I gave your lordships the reference yesterday in the closing where that was drawn to his attention. And the difficulty is, if you then go to 227, its conclusion as to breach of the revised schedule, and it leads on at 344, 345 only to the 17th of June. And our complaint in our notice was, our pleaded case was also the 11th of July, and he just doesn't deal with that. Because what he's done is looked at the position up to the 17th of June. And then the last point, which again is a new point on my learned friend's feet, is the suggestion that when you look at the 15%, you can somehow say, well, they're not accurate, so you add some more masks in. That is a brand new point this afternoon. Our permission skeleton was served on the 28th of August 2024, which had the table that we've been looking at with the 2 grey columns. Our skeleton for the appeal was the 31st of October 2024. My learned friend's composite skeleton in response was the 21st of February of this year. So he'd had it by then for 4 months. Nowhere in that skeleton will you find any suggestion that the production reports are incorrect on the dates we've identified and that you should add back in. And in particular, in relation to the second of those, the way he tried to do it was go back a number of days and add 500,000 a day to get over his figure. There's no evidence to support that. This point was not, again, addressed at the trial and is not in my learned friend's skeleton. And my submission is just not open to him, and there's no evidence to support that. You have the documents, you have what the judge didn't deal with, and we submit that's the end of it. My lord, it's 20 past 4.
Well, thank you very much. We will reserve our judgments. I think it very unlikely, probably to vanishing point, that you'll get them before the end of term. If we're able to produce something during the vacation, we'll probably send it out, but it may be that you will need a bit longer than usual because of whatever your arrangements are to deal with any consequential matters. But once we are in a position to send it out, then we'll probably want to hand it down quite promptly so that there is not a non-final judgment lurking in the ether. You'll be aware of the terms of the embargo, which we take very seriously, and we hope that once you have the judgments, you will be able to agree an order to reflect whatever we decide. If you're not able to do that, we will have short submissions in writing and make our ruling without a further hearing. So we're very grateful to you all for your assistance, and congratulations on finishing a 3-day case in 2 days without, I hope, anybody feeling that they were unduly pressured to get a move on.
What were I able to?